All right. Hey, everyone. Happy Wednesday. So good to be with all of you tonight. And it's hard to believe, but this is our last night together. So we are going to pick up where we left off. We do have a lot to cover tonight. And that means that we're going to start off on page 102. That's where my notes have us picking up on. So I hope I'm not overlapping any information that we talked about last week. And then we'll finish Unit 5, and then we will go into a comprehensive review. All right. And just kind of looking ahead, there is a coach's corner on Sunday. Jen will cover that. She will be leading you through the SHRM body of competencies. So it's called the body of applied competencies and knowledge. I believe that's what it stands for. So she's going to break that down for you, and she's going to talk about that on Sunday. Okay, so without further ado, let's go ahead and dive in. All right, so where we left off, we talked about concession bargaining. And so the next thing that we need to cover, because we talked about labor relations legislation. So now we're going to turn our attention to and focus on, if you will, national emergency strikes. Oh, you know what? Actually, I think we did cover this on Wednesday last week. I think this is one of the last things that we covered. But I'm going to go ahead and bring us back to a little refresher here. So, which act allows the president to apply for injunction to restrain a strike when the strike impacts health and safety? Does anybody remember which act that was? There were four that we talked about last week on Wednesday. And one of those four is the one that allows the president to apply for that injunction. Anybody remember which one that was? Was it Norris LaGuardia? Was it, let's see here, the Landon Griffin? Was it the Wagner Act? Or was it the Taft-Hartley? Yep, it was the Taft-Hartley. So you got that right. So not to confuse that with Norris LaGuardia, which directed that the courts are not allowed to decide the legality of a strike. So just to kind of refresh us, the Taft-Hartley gives the president the power to intervene when a strike becomes a national emergency strike. And national emergency strikes are those that can render national health or safety. The president then can appoint a board of inquiry charged with making a report of that situation. And based on that report, the president could apply for an injunction restraining the strike for 60 days. If there has not been a resolution at the end of 60 days, the injunction can be extended for another 20 days. And during that period, employees are polled in a secret ballot to determine their willingness to comply with the terms of their employer's last offer. So there was a example of this. If you go back to the early 1980s, and the Professional Air Traffic Controllers Organization, the union declared a strike seeking better working conditions, better pay, and a 32-hour work week. And Ronald Reagan, the president at the time, declared that the Professional Air Traffic Controllers Organization strike was a peril to national safety and ordered them back to work under the terms of the Taft-Hartley. Only 1,300 of the nearly 13,000 controllers returned to work, though. Okay, so let's go to our knowledge check. Let me just launch that in the poll. Give me just a moment while I go look that up for us. Bargaining issues like wages, salaries, and pensions are they mandatory bargaining issues that can be bargained to an impasse? Are they mandatory bargaining issues that cannot be bargained to an impasse? Are they voluntary bargaining issues that can be bargained to an impasse? Or are they voluntary bargaining issues controlled by the employer? I'll give you a couple seconds on that one. Okay, I'm going to go ahead and stop the poll there. And the answer here is, let me get my highlighter out. The answer is A. So mandatory bargaining items include wages or salaries, hours of work, subcontracting, stock purchase plans, profit sharing plans, pension, and employee welfare plans. So labor management must bargain in good faith on these mandatory items, and they may bargain to an impasse without violating the unfair labor practice provisions. Okay, so other things that you can find on the Hive. So bargaining structures are there. There's a lesson there on the Hive for that. There is a lesson on the Hive for maintaining non-union status. And then the last lesson there in this particular area is public sector labor relations that you can find on the Hive. All right, so let's move on and talk about grievance systems. Does anyone have a grievance system in the company that you work for now? Anything formal? Maybe you have something informal. So that's what we're going to do. We're going to talk about the grievance process for large and small companies. And then we're going to dive into a discussion about the differences between arbitration and mediation. So a grievance system. So some examples are, what are some examples of grievable items? Anything that you can think about that employees might bring to the employer, or if they work for a union, their attention in terms of items that, yeah, benefits is a good one. Yeah, the most common unsafe workplace. Yeah, exactly. So the most common examples are the ones that we're talking about here. Yep, harassment's a good one. Job duties, absolutely. So pay and benefits, bullying, work conditions, workload, those are all common examples of employee grievances. I want to share with you an example of an organization. Anyone work for FedEx or maybe has worked for FedEx in the past? So FedEx has or I think they have one. I think it's still relatively current. In any event, I'm going to use them as an example. They have what's called guaranteed fair treatment process. And it's sort of a turbocharged grievance process. It goes beyond grievance procedures in a couple of different ways, but most notably in that the appeal can go all the way to FedEx's top executives. So they call it the GFTP, the Guaranteed Fair Treatment Process, and it's available to all FedEx employees. It covers concerns regarding matters like disputed performance reviews, disciplinary actions, terminations. Employees, what happens is they can get a packet available from HR, and that's where they have all of the information in that packet to be able to file the complaint. Then HR has another file, if you will, or folder where they keep all of the completed documents for that particular employee, right? So the employee, of course, must try to resolve the problem with their supervisor before filing the GFTP appeal. The GFTP contains 3 steps. In step 1, management review. The complainant submits a written complaint to a manager. And within 7 days of the occurrence of that issue, then the manager will hold a telephone conference or meeting with the complainant. They'll make a decision to either uphold, modify, or overturn management action and communicate their decision in writing to the complainant. If they are turned down in step 1, then in step 2, that goes to an officer complaint. So the complainant submits a written complaint to an officer, and within 7 days, there needs to be a response from the officer. And then finally, if necessary, in step 3, executive appeals review takes place. That's where it goes. The complainant submits a written complaint within 7 calendar days of the step 2 decision to the Employee Relations Department. The department investigates and prepares a GFTP case file for the appeals board executive review. The appeals board is usually the C-suite, so the CEO, the COO, the chief HR officer, and some senior vice presidents. Then they review all relevant information. They make a decision to either uphold, overturn, or initiate a board of review or make other appropriate or take other appropriate action. So the appeals board decision at that point is going to be final. All right, so let's talk about what the grievance process looks like in a unionized environment. So again, a grievance is generally defined as a claim by an employee that they were adversely affected by the misrepresentation or misapplication of a written company policy or collectively bargained agreement. So to address grievances, employers typically implement a grievance process. The grievance process may also be part of the collective bargaining agreement. So a grievance is a means of internal dispute resolution where the employee may have their grievances addressed. Most collective bargaining agreements include procedures for filing and resolving grievances. And with a union environment, the processes will typically involve the employee, union representatives, and members of the employer's management team. So the grievance process may differ somewhat from employer to employer and under collective bargaining agreements. However, most of them have certain general processes in common. Grievances are brought to the employee's immediate supervisor, which we can see at step 1. And this may be either an informal process or the beginning of a formal process. And then the next step is that if it doesn't get resolved there, then it would go to the business agent for the union and the superintendent that would represent the organization. The third step would be to take the grievance to the plant grievance committee and then the industrial relations manager. The fourth step, so this is one that you don't see unless you are in a larger organization. So larger organizations will have this fourth step where they'll bring in international union representatives and corporate officers, but only in bigger companies. And then step 5 would be arbitration if it doesn't get settled at the lower steps. Right, so that's what it looks like in a unionized environment, but what does a grievance process look like in a non-unionized environment? So here what we see is that we could use, now what I want to preface us by saying here is that you could use any one of these processes or methods that are listed on this slide individually, or you could use it in combination with one. Like, for example, you could have a grievance committee and you could have a fact-finding method. So they could go hand in hand. So let's just kind of break each one of these down. So let's first talk about the grievance committee. The primary purpose of the grievance committee is to review a complaint that has not been resolved at the staff or administrative levels, and to provide mediation when appropriate. It's the job of the committee to evaluate any issue in a more thoughtful and respectful manner without allowing any emotions involved to overwhelm the work. The committee will be as impartial as possible, and they'll strive not to prejudge any individual or situation. Then we could go to a omnibudsman. So the omnibudsman reports to usually like the highest level of leadership within the organization. So it could be the company president, and it's typically an in-house employee who investigates and works to settle employees' complaints. You could have a grievance appeal procedure. So this is a hearing set up where the aggrieved employee is represented by a lawyer, or it could be HR, and undergoes a more formal process where a neutral positioned executive will render judgment. Then we move to an open door policy. So employees of any level may approach a position of authority with the reassurance of no reprisal and the utmost confidentiality. So hierarchy doesn't exist within an open approach policy. And then the last piece here is the fact-finding method. So this is an investigatory process of employees' complaints conducted by HR or a member of the executive team. So this is fact-finding a company's discovery with recommended next steps like discipline, transfer, things like that. All right, so how do we make sure that our grievance process is effective? Grievance procedures, we know, are a means of dispute resolution that can be used by a company to address complaints by employees. A grievance procedure provides really that hierarchical structure for presenting and settling workplace duties. So when an employee feels that they have been maybe not treated equitably or something's gone wrong, be it like an unfair paycheck or an unpleasant assignment, they can file a grievance with the company that they work for. So, what does a grievance process look like? The exact process is going to vary by company, but usually it looks like something like we talked about before. The employee makes a formal written complaint, or it could be a verbal complaint. The official investigation begins. The investigator writes a conclusion. A mediator may be called in, and then there are consequences. And if the employee isn't happy with the outcome, they can take their grievance to court. So, what does an effective grievance process look like? So, it needs to have a couple of elements in it. It needs to have one, there needs to be the understanding that the employee will be protected against retaliation, meaning that their complaints can be presented without a lot of hassle, embarrassment, or paperwork, that their complaints will be evaluated by a fair and impartial third party, and that they'll not be fired or mistreated for submitting their complaints and pressing them to resolution. The second component is that employees must trust that the process will provide timely responses. So most grievance procedures specify time limits for each stage of grievance processing. An agreement may stipulate, for example, that a grievance must be filed within a certain number of days after an alleged violation takes place. The organization is required to respond within a certain number of days at each stage of the procedure. And the purpose of such time limits is to force both the company and the union to address grievances immediately. If grievances are resolved promptly, friction and discontent are reduced. And then the last component that you want to have in your grievance procedure is that employees need to believe that they'll be given fair consideration. So to resolve a grievance, both management and union must be willing to discuss the issue rationally and objectively, and both sides must desire to resolve the dispute and to work toward a satisfactory solution. All right, so let's go to, we got another knowledge check here. Let me just go to the poll. All right. Oh, that's the wrong one. Sorry about that. Okay, so which of the following contributes to a more effective grievance procedure? Would it be requiring that complaints be submitted in triplicate to avoid losing them? Requiring supervisors at 2 levels to sign grievances to reduce frivolous complaints? Would it be posting all complaints on a bulletin board to make them public? Or promising employees that they will not be fired or mistreated for rocking the boat? Okay, I'm going to go ahead and end the poll, and the answer here is D. So promising employees that they won't be fired or mistreated for rocking the boat. That's one of the things that you want to make sure if you go back to those 3 things that we talked about in the slide before. Okay, so next we're going to focus in on employee discipline systems. And the objective in this section will be to analyze the components of employee discipline and talk about administrative justice. So first, we're going to break down employee discipline systems. So the objective is to, obviously, when you put discipline in place, you're trying to remedy a problem and overall just help the employee achieve success in their work. So there's three kinds of punishment that we see here. There's the natural, which means that behavior violates the laws of nature or society. There's the logical, which means that punishment has a logical relationship to the violation. So in other words, the punishment that should fit the crime. And then it's contrived, which means punishment is unrelated to the behavior and therefore is least effective. And this slide shows the different ways to approach discipline. So when we look at negative, there are two sides of looking at discipline. We could look at it as a negative approach, how we kind of how we approach discipline, right? So it could be retribution or punishment for errors, and then our emotional tone is anger. We terminate the offender, serve as an example, put fear in them, and then the employee will achieve only a minimal acceptable performance. So that's kind of the outcome, or that's the consequence of doing the negative approach. The positive approach, obviously the right side, is where we really want to focus. So we want to really hone in on how to correct the behavior and eliminate any errors. We want to be calm in our emotional state. We want to make sure that we are looking at, it's more of how can we rehabilitate the employee and make them more productive rather than trying to make them feel, kind of bad or, a little bit humiliated. And then we want their response to be that they want to be a good employee and that they want to improve their productivity. So part of discipline is the progressive process. Does anyone have progressive discipline in your organization right now? Anyone do that? Anyone have like a step process, like, we do this and then we do that? So yeah, so I see a few of you are saying that. Does anyone not have a progressive discipline policy in place? Or maybe you don't even have like necessarily a disciplinary process outlined or communicated in your handbook. Yeah, it's interesting. So why do you think that a company would take the stance of not having a disciplinary process? So why would a company not have a disciplinary process? Some of you who are used to that are probably thinking, oh my gosh, that's setting themselves up for liability. But there's reasons. There's some strategy behind that, right? So the reason why a company would not have maybe a published this progressive discipline process would be that that they wouldn't have to. It gives them more, sometimes what they believe, it gives them more leeway to be able to address a situation. Yeah, exactly. But it's not that they necessarily have to go from, like a verbal to a written to a suspension to a performance improvement plan to finally a termination, right? Exactly. The one thing to keep in mind, though, is has anyone heard the terminology, your practice becomes your policy? Anyone heard that before? So yeah, right. You're setting a precedent, exactly. So when you start, even if you don't have something published, a lot of companies will think, oh, we don't have anything published and we can do whatever we want. That's not necessarily the truth, because a court of law will look at it and say, well, this is how you handled this situation in the past. So that's really your practice, right? So progressive discipline is that process in which the severity of consequences increase as disciplinary action is taken. So the key is to apply the steps within the process consistently across all situations that are in violation or don't meet expectations or, are, of a wrongdoing type of nature. So 5 steps are listed here, and this varies within companies. Some companies have 5, some have 4, some have 6. This depends on what the organization decides is going to be their mode of discipline. But here we see in this example, we're talking about verbal warning. So this is a verbal discussion identifying the action. It's recommended that you do document, however, and file that a conversation took place. The verbal reprimand, so consequences are delivered verbally with clearly identified and understood rules and expectations. And here, what it's important to note is that the employee letting them know what will happen next if the undesired behavior is repeated. So this verbal discussion too should be documented and filed in the employee file. And then number 3 is the written reprimand. So this is a written description of the problem, consequences, enforce corrective action or actions, and punishment if repeated. Both the manager and the employee would sign that document and file it in the employee's record. A copy would be provided to the employee and the union steward. Yeah, so you might add, someone makes a good point, you might add a performance improvement as part of the process in there, which is what a lot of companies do. Then we could go to a suspension, and then of course the final step would be a termination. So question for everyone, how would you handle a situation if an employee was presented with, well, let's say a written disciplinary, like an action, a disciplinary, and a notice of disciplinary action, we'll just say that, a written one. How would you handle it if the employee decided they refused to sign it? What would you do in that situation? They said, nope, I'm not signing it. It's not accurate. What would you do? Okay, you could put a note to refuse it. Okay, right. They don't have to put a note on it. Yeah, the other thing that you could do, there's a couple of different things that you could do. You could let them know, yeah, you have a witness and you sign it. Yep, that's a good one. So if there's a comment section, you could let them know that they're free to make comments in there. And you could also reinforce to them that by signing it doesn't mean that they agree with it. And usually, a lot of times we're actually in the process of redoing our disciplinary action documents right now. And one of the things that we noted on there is we put a little disclaimer there down at the bottom that states that this is an acknowledgement, not necessarily an agreement, right? Someone sharing that we had a situation like this and they wanted some things changed or they wouldn't sign it. Yeah, let them know signature does not mean that they're admitting guilt. Yeah, exactly. The other part of it is that you could have them write on there that they refuse to sign it. You could sign it, have a witness sign it, and say, just write on there that the employer refused to sign. So there's a couple of different things that you could do there. The most important takeaway from this is that although although it may not be that you're like coming with one hard stance, is that if you ever had to prove in a court of law, if they said, oh no, I didn't receive it, that you would be able to defend your position and say, yes, in fact, we did have this conversation, it was delivered. So that's really what you're kind of getting at, is that whole making sure that you've got documentation of the fact that the conversation took place. Yeah, so let's see here. So there's a yeah, right. I'll make a little joke. So someone is saying, so the signature to provide they received it. Right, exactly. So yeah. Yeah. So you want them, so if they sign it, then they're just agreeing to the fact that they received it, not necessarily that they agree with what is stated in it. It's just that they received it, that they had that the conversation took place, essentially. Yep. Okay, so let's talk about administrative justice. So there's two components to administrative justice. There's due process. So a system of administration, if I can talk, there we go. A system of administrative justice has evolved over time that's generally accepted in most organizations and formally adopted by collective agreement in many union contracts. So two basic concepts supporting administrative justice are due process and just cause. So due process describes the disciplinary actions that must follow an accepted procedure that protects an employee from arbitrary and unfair treatment, and just cause are the disciplinary actions that should only be taken for good and sufficient reason. Okay. Oh, can you hear me? I'm still here. Did I cut out? Okay, there we go. All right. I just stopped for a minute. I was reading a note here real quick from someone. It looks like I missed a couple of slides. Are you guys getting that? So, from where we left off last week, I thought we left off on page 102. I'll have to go back and check my notes on that one. So, okay, so let's go. So while we're, I'll have to go check while we're on a break here, but let me go to the knowledge check. Let me launch that poll here. Okay, and oh, that is not the right knowledge check. Give me just a moment. See if it came up here. Hold on, guys, just a second. Okay, there we go. All right. Okay, if an employee in a union company has a grievance against the company, who should help them process the complaint? Would it be the union, but it's only required to process the complaint if the employee is a union member? The union, the Taft-Hartley Act, states that the union must represent all employees in the bargaining. Oh, did it not launch? Oh, darn it. Okay, hold on. Let me stop sharing. Let me see. Thank you for letting me know. Relaunch it. That's what it wants to do. Technology is not my friend tonight. Okay, there we go. All right. So how about that? All right. So the NLRB, okay, perfect. The NLRB, the Wagner Act, requires it to represent union members in civil courts or the company's grievance committee. Employers are required by the NLRB to have a grievance committee to represent aggrieved employees. Okay, I'll give you a couple seconds on that while I go over to answer a quick question. Okay. Oh, I'm sorry. I see some comments in here. Are you guys having difficulty with the poll? It's still there. It's still launched, I think. You can always type in chat oh, it's not there. Ah, okay. Let me see. All right, let me end it. Okay, someone's saying that they saw and voted it, so it looks like half did, half didn't. Oh, geez. Okay. All right. I'm going to go ahead and I just ended it. So let's see what happens. Oh, but you didn't, yes, voted, but it wasn't happening. Okay. All right. Okay. Not sure what's going on with that. Okay. We'll have to see what happens with the next one. I'll watch that. Okay. The answer here is B. The Taft-Hartley Act requires a union to represent all employees in the bargaining unit, even if they're not members of the union. So, okay. So the Taft-Hartley Act, requires a union to represent all employees in the bargaining unit, even if they're not members of the union. Yeah. Okay. Okay, sorry guys, give me just a minute here. Okay. All right. So let's go into arbitration. So arbitration is the process of having a labor dispute resolved by an impartial third party who examines information from both sides and renders a judgment. So the parties agree beforehand to accept the decision of an impartial judge who is considered to be known as an arbitrator through a submission agreement. So a large part of the growing cost of arbitration is the increased formality of the hearings in adhering to legal procedures. So the trend in arbitration is toward using lawyers, having more formal grievance hearings, examining more testimony, and using more technical language in labor agreements. So to make arbitration less costly and time consuming, companies could establish a panel of arbitrators and then they could select an arbitrator to hear their complaint, similar to a procedure adopted. This has actually been something that's been used in the steel industry for years. In that industry, cases are presented by the local plant and union representative through written transcripts or briefs, and an award is made within 48 hours of the hearing. So these speedier hearings significantly reduce the cost and dramatically decrease the time required to process a complaint. So that's really kind of the push toward the trend, if you will, in arbitration. All right, so let's look at alternative dispute resolution. And these are the different formats or methods, if you will, of how you could dispute a a situation or a disagreement. So the first one is negotiation. So two parties independently arrive at a resolution. Mediation is bringing in a neutral third party who aims in productive conversations to arrive at a solution. Binding arbitration is where a neutral third party renders a decision by which both judges or both parties have to oblige. So both parties are required to, whatever that arbitrator says goes is what they have to agree to. And then the last one is rent a judge services, and it's really just like it sounds. So it's an elective service sourced by the two parties to speed up a binding decision, because obviously when a judge makes a judgment call or a decision, then that is what both parties are bound to. Okay, so let's go to the next knowledge check and let's see how this poll works. If this one is less glitchy, I'll just put it that way. I'll just call it that. Let me see, make sure I got the right one here. No, that's not the one. Hold on. Let's see. Sorry, guys. Oh, you took this one already. Okay. It's a repeat then, huh? Okay. Sorry about that. Yeah, it is. You're right. Okay, the answer is D. Everybody got that one. Okay, that's a gimme. All right, perfect. Oh, these are repeat slides. Sorry about that. It ended up getting in here twice. There we go. That's where we need to be. So let's go to individual. And hold on a minute here. Let me make sure I'm in the right spot. Okay, so we're at individual employment rights. So here, the objective in this section, what we're going to do is we're going to talk about employment at will and the relationship that it has to implied contracts. Then we're going to talk about the different reasons leading to employee dismissal and the appropriate recourse or course of action, if you will. All right, so we talked about employee handbooks. And we had a discussion about this. I believe it was in Unit 1. I think it was Unit 1, I'm pretty sure. So what's the difference between an employee handbook and a policy manual? Anyone know the difference? This is a good refresher, recap of what the difference is between the two. What would you say is the difference between the employee handbook and a policy manual? Handbooks are what, and policy manuals are what? Okay, policy supersedes. Yeah. So handbooks are, they're not required. Yeah, policies can be updated. Yeah, the other part of it is that handbooks are a summary. Remember, handbooks are a little bit more general, yeah, and policies are much more specific, exactly. So a policy manual is more detailed. So, for example, in an employee handbook, you could talk about the drug-free workplace policy. You can mention it in an employee handbook, but you may not go into a lot of detail about, like, this is this is what the procedures are. It just says that we are a drug-free workplace, and then refer to the drug-free workplace manual, or, policy manual, right? So a policy manual gets much more detailed and specific, whereas the employee handbook gives a general overview. Like, for example, a code of conduct would be a policy. What's the most important reason for having an employee handbook? Any thoughts on that? Why is it important to have an employee handbook? Someone mentioned that it's not required. Yeah, it's not legally required, right? So you're not going to serve as a resource. Yeah, it's a central information source that has information like, it's a guideline for employees. Yep, it's company information. Employees can read it in their own time. It's an outline of what they can expect from the company and what the company expects from them. It also, here's the interesting thing, because they've evolved over the decades, right? It provides a tone for the company. You can kind of get a sense when you read the employee handbook if the company is a little bit more formal or a little bit more informal, right? Sometimes some other things to think about with employee handbooks that I think we talked about before is that to make the employee handbook more readable, maybe have less content in it. That's why we have policy manuals. I remember back in the day, oh my gosh, those employee handbooks were hundreds of pages. It was awful. Yeah, explaining the employment-employee relationship. Yeah, and have it in relatively simple language, right? So think about your audience. Make sure that it doesn't have a lot of, term like jargon or any complex terminology. You want to make it a relatively easy read, right? Okay, so let's talk about employment at will. So most employment is at will, which means that there's no fixed period time that the employment relationship will last, and either party is free to terminate the relationship at any time with or without cause. So in other words, the employer may fire or the employee may quit for any reason or for no reason at all. And in almost all cases, there is a presumption that any particular employment relationship is at will. So the presumption applies unless it's shown that employment for a specific period of time, like 2 years, was intended. So the fact that the employer and the employee intended the relationship to last a long time or for an infinite period of time doesn't overcome the presumption of employment at will, since in most cases, the parties hope that the relationship will last a long time or indefinitely. So an employer's promise of work for as long as the job exists or for as long as the employee wants to is nothing more indefinite, and it's at will. So even so-called permanent employees are still what's considered to be at will, but you do have to be careful, and we'll talk a little bit about that. So what we see on the slide here is this is some language that I actually pulled out of a offer letter, and it just talks about the fact that this organization, usually offer letters will have some kind of caveat in there or some kind of disclaimer that says that we are at will. So the questioning is coming up, and that's a really good question. And I'm actually, pardon me while I take a quick second here I'm not positive on that. The right to work actually has a little bit more to do with unionized situations. But let me just do a quick, you guys can hang on with me just a minute. Let me just kind of look at that real fast. So the right to work versus it's the employee's ability to choose whether or not to join a union, as a condition of employment. And at will means that either the employer or the employee can terminate the relationship. So there are certain states that are, yeah, so Texas is a right to work state. So that means that the employee has the option. They don't have to join, it's not a union state, meaning that um, so if you were in a state that was not, what's the opposite of that? If you were in a state that's not a right to work state, then like a union shop, I think is what it's called. Then if it was a unionized, they would have like so many days to join the union if it was a position that was in a unionized or represented role. So yeah. Okay. All right. So let's move on and talk about implied contracts. So an implied contract consists of a verbal or written promise by an employer to continue the employment relationship either indefinitely or for a designated period of time. An example of an implied contract is a statement in an employee handbook that the policy of the company is that non-probationary employees will not be released except for just cause. So employee handbooks can create an implied agreement by referring to employees as permanent employees or to jobs as steady jobs. So kind of keep that in mind, right? And I just added this in here as sometimes there's an implied contract with job security, the right to fire, how long the employee has worked for the employer. Okay, let's go to the next knowledge check. All right, let me know how that works for you in terms of the poll. It looks like it's there. Okay, I see people responding. So the idea that employers can dismiss employees for good cause, for no cause, and even for causes that are morally wrong without breaking the law is that progressive discipline? Is that just cause termination? Is that reserved rights theory? Or is that employment at will? Okay, I'm going to go ahead and close that poll. And the answer here is employment at will. So the philosophy of hiring whomever you want for, excuse me, as long as you want, is called the employment at will doctrine. At will employment, in essence, allows both the employer and the employee the mutual right to terminate the relationship at any time for any reason and with or without advance notice to the other party. Okay, so let's move on and talk about, we're going to talk a little bit about discharges. So the first one is retaliatory discharge. So retaliatory discharge alludes to a business firing an employee for something other than a work-related reason, like job performance. So an example might be that if an employee complains about harassment or discrimination, the employer cannot take an action against the employee. Unfortunately, retaliation in the workplace does in fact happen, and according to the EEOC, more than 1/3 of discrimination charges filed with the EEOC in the past couple of years have included a claim of retaliation. And courts have ruled that employers were guilty of terminating employees in retaliation for actions that were legal but contrary to the interests of the employer, such as filing a workers' compensation claim. So employers have been sued by employees and subjected to tort liability because they dismissed employees for reasons that violated public policy. And those improper dismissals have also been labeled as wrongful discharges or retaliatory discharges. Okay, so let's talk about job as property doctrine. So legal theory called the job as property. Oh, there we go. Yeah, exactly. Like someone saying whistleblower. Yep. So legal theory called the job as property doctrine states that employment is a fundamental right of American workers and that the loss of employment has such a serious impact on someone's life that individuals should not lose their jobs without the protection of due process. Um, and affording due process means recognizing the employee's rights to be informed of unsatisfactory performance and to have a chance to defend themselves and improve before an adverse employment action like discharge is taken. So the property right protection places on management an obligation to deal in good faith with employees and to take corrective action measures based on just cause, in other words, for good reason. So this just cause requirement mandates that businesses take corrective action measures only for clear, compelling, and justifiable reasons. So according to Supreme Court precedent, some civil servants had a property interest in their job and as a consequence received due process protections under the Constitution before they could be fired. So a property right exists where state or local laws provide that the employee will only be disciplined or dismissed for cause, just cause, proper cause, or sufficient cause. Okay, so let's talk about constructive discharge, also referred to as constructive termination. That's when an employee chooses to leave their employer after an adverse work experience. It could be just one negative incident or a pattern of negative behaviors or actions, but the employee decided to leave because they could no longer work in that environment. So when working conditions become so unpleasant that a reasonable person would find them intolerable, the courts have constructed from the facts of the case that the person was actually terminated. So causing an employee to quit by creating unpleasant working conditions violates the law when it's used to discriminate on the basis of disability, age, race, religion, sex, and other protected classifications. Yeah, so hostile work environment, exactly. You got it. So in a typical voluntary separation, the employee is not eligible for unemployment benefits, but for constructive discharge, if proven, is considered a form of involuntary termination and therefore eligible for those particular benefits. So, if an employee has disability and requires certain accommodations to perform their job, but doesn't receive accommodations from their employer, they may experience a hostile work environment where they feel forced to provide a resignation. So, for example, not having wheelchair accommodations for employees who need them may lead the employee to request better mobility access and to be denied or punished for their request. Okay, so let's look at the next knowledge check. So an illustration of constructive discharge is firing incompetent laborers. Oops, did the launch? I'm sorry, let me see. It didn't launch. Hold on a minute. Okay, there we go. It should be showing up now. Okay. So an illustration of constructive discharge is firing incompetent laborers, laying off the least senior employees, terminating minority employees, or assigning unpleasant work to older workers to make them resign. Okay, I'm going to go ahead and end the poll. And the answer here is D. So, causing an employee to quit by creating unpleasant working conditions violates the law when it's used to discriminate on the basis of disability, age, race, religion, sex, or other protected classification. So, employees who quit can be reinstated and receive back pay on the legal theory of constructive discharge when working conditions become so unpleasant that a reasonable person would find them intolerable. The courts have constructed from the facts of the case that the person was actually terminated, even though the company claims the employee quit and even though the employee may have submitted a letter of resignation. Okay, so this next one is a little bit of a matching uh, exercise. So we're going to go ahead and go to the type of discharge on the left and match it to the term or the explanation on the right. So the first one is involuntary. Is that retaliation toward employees, legal actions, termination of the employment relationship without choice, assigning unpleasant work to older workers to make them resign, or legal with or without cause? Okay. And you guys are right. The answer is two. So it is involuntary termination of the employment relationship without choice. Okay, how about B, wrongful? Is that number one, retaliation toward employees' legal actions? Is it number three, assigning unpleasant work to older workers to make them resign? Or is it four, legal with or without cause? Okay, and it is one. So wrongful is retaliation against employees' legal actions. Okay, how about C? So constructive. Is that assigning unpleasant work to older workers to make them resign or legal with or without cause? Okay, yeah, it's three. So constructive is assigning unpleasant work to older workers to make them resign. And then D is number four, which is employment at will, which is legal with or without cause. Okay. All right. So let's talk about common law tort theories. So, let's kind of walk through a little scenario here. So, upon arriving at work one morning, you find Jennifer, a longtime member of your company sales force, waiting in your office with tears in her eyes. She's come to tell you that her boss, Richard, has been sexually harassing her for the past 6 months. Jennifer says it started with invitations to go out for drinks or dinner after work. It escalated when, on several occasions, Richard put his hands on her shoulders and began giving her a massage. Jennifer tells you that once, despite her protest, Richard would not let her get up from her chair. A few months ago, Richard began to accompany Jennifer on out of town business trips. For the first time in many years, Jennifer says on a recent trip, Richard came into her hotel room, stood by the door, and refused to let her leave until she agreed to go on a date with him later that night. Now, Jennifer eventually told Richard she was not romantically interested in him. After that, Richard started giving her bad performance reviews and spreading false rumors about her both within the company and amongst customers. As an HR professional, you undoubtedly are familiar with the liability that your company might face, right? If Jennifer brought a sexual harassment lawsuit under Title VII of the Civil Rights Act or a parallel state or local anti discrimination statute. What you might not realize, however, is the extent to which Richard's conduct may also have exposed your company to even greater liability under common law tort cases of action. So, tort is considered to be a catch all legal term that encompasses various intentional or accidental civil wrongs against a person or property. So, based on the events Jennifer has described, she could pursue claims against the company under intentional tort theories ranging from assault and battery to false imprisonment, invasion of privacy, defamation, and intentional infliction of emotional distress. All right, so let's talk about defamation. So, defamation is an intentional tort that provides targeted individuals with remedies against persons who intentionally make malicious statements that injure the target's character. Generally, the truth of the statement is a complete defense in a suit for defamation because true statements are not considered to be malicious. And then we go on and talk about slander, involves spoken words. Libel is going to be the print. So let's go back to Jennifer and Richard. So thinking back to our initial, oh, sorry about that, to our initial hypothetical, it should now be apparent how Richard's conduct has exposed his employer to a wide range of tort liability in addition to the company's more obvious liabilities under anti-discrimination laws. By giving Jennifer massages against her will and blocking her exit from the hotel room, Richard has subjected the company to potential claims of assault and battery. A jury could also find that those same actions could give rise to tort claims for false imprisonment and invasion of privacy. In responding to Jennifer's statement of disinterest by giving her poor performance reviews and spreading rumors about her, Richard also exposed the company to a defamation claim. And finally, given the totality of Richard's conduct, it's not hard to imagine Jennifer pursuing a claim for intentional infliction of emotional distress. Okay, so let's talk a little bit about non compete agreements. So, a contract that imposes restrictions on an employee's ability to compete with a former employer is enforceable in most states if restrictions are reasonable. The general rule is that an employee's agreement not to compete with an employer upon leaving employment will be upheld if the following conditions that we see here on the slide are met. So the restraint is supported by adequate consideration. So, for example, uh, you know, uh, giving them time to be able to, look at it. So the shorter the agreement, the more likely a court is to find it reasonable. Although there's really no clear-cut rule, agreements that last a year or two are more likely to be upheld than agreements that extend well into the future. Um, the it must be devoted or developed at the employer's expense. It must provide the employer with a um, competitive advantage, and the employer must generally. I think that got cut off. So let me kind of explain. So there's another piece of it, the area. So court is more likely to find a non-compete reasonable if it applies only to a limited geographic region in which the competition would truly undermine the employer's business. So how large an area is reasonable will depend on the industry. And what counts as competition, that's another one. So employers are more likely to win in court if they prohibit an employee from working for a short list of direct competitors or prohibit the employee from starting a new business in the precise field that the employer occupies. Okay, so let's go to a knowledge check. All right, so in order to prove a case of defamation, an employee must present all except which of the following evidence: that there was no legitimate business reason for the statement to be made, others believe the statement to be true, a false or malicious statement was made to another person, the person was harmed by the statement. Okay, I'm going to go ahead and end that. And the answer here is B. Let me get my highlighter out here. To prove a case of defamation, a person must show evidence that a false or malicious statement was made to another person, either verbally or in writing. The person was harmed by the statement, and there was no legitimate business reason for the statement to be made. Okay, so why don't we go ahead and stop there? Let's take a break. Right now on the clock, I show 7:05. So we'll take a break and we will resume at 7:10. We'll just take a 5-minute break. Okay, guys, and we're back. All right. So let's now move our attention to workforce behavior problems. And in this section, we are going to talk about problems in the workforce and then the impact to the environment. So workforce behavior problems, excuse me. So there's a wide range of behaviors exhibited by employees that can create risks for other individuals in the organization. So some general categories and examples include things like gossiping. While it tends to have both harmless and vicarious connotations, gossiping generally refers to the actions of an individual who habitually reveals personal or sensational information about others, displaying general incivility, bullying, we know that, exhibiting insubordination. And so some of the things that are used to address these issues are train the employees, provide honest feedback, maybe have listings of what's considered to be a violation and what the progressive discipline is associated with that. Another concern to talk about here is absenteeism and turnover, although absenteeism and turnover, whether it be voluntary or involuntary, aren't necessarily workforce behavior problems. They can certainly raise red flags that could lead to behavioral concerns. So computing the organization's job absent rate will help identify a problem if it exists. So absenteeism, keep in mind, is characterized as planned absences, unplanned absences, extended absences, and intermittent absences. So planned absences, those are the ones that are scheduled and approved. That's time away from work that's been planned for. Unplanned, obviously, these are unexpected instances that happen away from work, and there could be sometimes an absence for the, or I'm sorry, a pattern for the absences, like an illness. Extended absences, things that are longer than a week generally, are characterized as extended, and intermittent. They may last as long as a few minutes or as much as several days and may be caused by a medical condition. Now, to get a better sense of your absence rate, the way to calculate that is what's listed here on this slide. So this is a good formula to know and to understand and be able to apply for the exam. So we take our job absent rate and we look at the work days lost due to that absence divided by the number of employees times the number of work days, and that will give us our job absence rate. So if we look at an example down here, we said there were 400 days that were lost in 1 month, and 1,000 employees were scheduled to work 22 days. The severity rate, or the absence rate rather, is 1.8 when we multiply that number by 100. So if we put it in the context of what the heck does that mean, if you look at the Bureau of Labor Statistics, they actually publish something, I shouldn't say something, they publish some data here that talks a little bit about what is the average absent rate. So if you look at total, this is a total from 2021, a little outdated, but it says 3.1. So 1.8 is pretty darn good if you're looking at total 3.2, but then you can break it down by occupation specifically. So if you're looking to track, are we good here? Are we looking okay in terms of absenteeism? You can pull some of those statistics to do that comparison there. Oops, that's the extra slide. Okay, so let's now talk about drug and alcohol use. So under the Americans with Disabilities Act, so we have covered this previously in Unit 2, alcoholism is viewed as a disability, as a treatable disease. So an alcoholic is generally a person with a disability under the ADA, whereas someone who's addicted to drugs is protected under the ADA only if they are not currently using illegal drugs. So the question then comes into play. So what do you guys think here? Can an employer take disciplinary action against an alcoholic employee? Can they take disciplinary action against an alcoholic employee? Actually, they can. The key is to focus on the behavior and not the alcoholism. And it depends on the severity of the violation, and it needs to follow, obviously, how you discipline needs to be based on your policy, and you need to be consistent, right? Okay. All right, so bringing us back to sexual harassment, we talked about this in Unit 2 as well. So sexual harassment has a couple of components to it. The quid pro quo, which is this for that. So if you do this for me, then I'll make sure that you get that promotion type of thing. And then anytime there's any type of a hostile work environment, that could be considered to be a form of sexual harassment on anything that would be considered to be unreasonably interfering with work performance. Okay, so let's go to the next knowledge check. I just launched the poll here. Hold on a minute. Employees with alcohol problems should be fired immediately, treated with a lot of patience and understanding, required to accept help to keep their jobs if their performance problems are documented, or left alone to handle their own personal problems. Ending the poll. All right, so the answer here is C. So alcoholism is also a protected disability under the Americans with Disabilities Act. So consequently, disciplinary procedures must must focus rather, there we go, that sounds better, on performance discipline or deficiencies rather than on alcoholism. So employers have a legitimate and legal right to ensure competent job performance from alcoholics as well as non-alcoholic employees, although they are encouraged to offer rehabilitation assistance to those willing to accept help. So the deterioration in the employee's work should be described, and the employee should be told that discharge will result if no improvement is shown. And the ADA allows employers to obtain medical exams where there's evidence of a job performance problem, especially on jobs that could impact public safety. So if the report confirms the suspicions, the employee may be required to obtain immediate help or be discharged. This hardline position appears to be the best approach to handling alcoholism problems. Okay, so let's talk about organizational exit now. And here we're going to review the recommended procedures for handling employee terminations, and we'll talk about WARN. Termination. So involuntary terminations occur as a result of employment problems like poor performance, excessive absenteeism, insubordination, theft. Employers need to make sure that all involuntary terminations occur for job-related decisions, and that termination decisions do not violate any contractual commitments with employers. So before an employee is terminated, employers should have an established procedure whereby a designated person reviews the proposed termination. So it's just a way to kind of check and balance to make sure that there were valid reasons for the termination is due to a specific incident, determine whether the employee was aware, so doing that due process, determining whether termination is consistent with how we've treated other employees in the past, a review of the employee's work record, and ensure that the employee is not a victim of any type of retaliation. So kind of having just a little bit of a checklist, if you will. All right, so let's talk about termination interviews. So when we talk about a termination interview this is a termination discussion that would happen with an involuntary situation. when you have a conversation with an employee to let them know that their that their role is being terminated, how long should that conversation last? What do you guys think? I think the book talks a little bit, the course materials talk a little bit about how long it should last. Any thoughts on how long that should last? Yeah, 15 minutes, it says. Yeah, short, sweet, to the point, right? So there are typically two types of separation conversations that take place. One would be an exit interview for voluntary, and the other one would be the separation conversation for a involuntary separation. Um, the reasons why you hold a meeting is that employers don't want disgruntled employees remaining on the premises. And in too many instances, that's kind of a recipe for conflict of various kinds. Second, you want to make sure that you get company equipment from the employee, let the employee know about things like COBRA. And then finally, you want to make sure that if there's a severance to offer, that you offer the severance in consideration of an exchange for execution of a release by the terminated employee, making sure that you have a well-drafted release statement. So, all right, so let's talk about layoffs and reductions in force. So layoffs occur when employers need to eliminate positions in order to maintain profitability. Conducting a layoff is not an easy process. I think most of us have probably been in that situation. So when we're talking about a layoff, that's a situation where, as opposed to a reduction in force, a layoff is a situation where it could either be, I've seen some situations where they say indefinite layoff or a temporary layoff. So it could be a situation where you plan on bringing somebody back if you do a layoff. A reduction in force means that you are reducing that position and the likelihood of bringing somebody back. In that particular scenario, it's very unlikely that someone would be brought back to their role if there's a reduction in force. So, steps to do that to prepare is select the employees, to look at, if there's any group that's going to be adversely impacted, review any kind of state, federal regulations that impact your industry. Put together, the severance packages, the separation letters, make sure that you've got kind of a Q&A type of format available, contact list, phone numbers, and then, of course, an exit checklist to make sure that you've got all of their equipment, passwords, things like that, company property. Okay, so now we move on and we talk about, yeah, that's a really good point. Know who your protected workers are. Yeah. So let's talk about WARN. So this is the Worker Adjustment and Retraining Notification Act. It requires companies with 100 or more full-time employees to give 60-day advance notice of plant closings or layoffs that affect large numbers of employees. So it's a law that helps employees who are scheduled to lose their jobs know in advance about pending layoffs so they can begin making alternative plans. For plant closings, notice is required when 50 or more employees at one site are to lose their job. For layoffs that are scheduled to last more than 6 months, notice is required if it affects 50 or more employees who comprise at least 33% of the workforce at one site. Notice isn't required if the layoff is caused by natural disasters or business circumstances that could not have been foreseen 60 days in advance. So the penalties, can get pretty steep. There's daily penalties that can really start adding up. So employers need to be aware of that. All right, so let's go to the next knowledge check. The Worker Adjustment, Retraining, and Notification Act requires employers to retrain displaced workers before terminating them, provide personal counseling for terminated workers, give 60-day advance notice of a layoff or plant closing, provide alternative employment for displaced workers. Okay, I'm going to go ahead and stop us there. And the answer here is C. So the Worker Adjustment and Retraining Notification Act, WARN, requires companies with 100 or more full-time employees to give 60-day advance notice of plant closings or layoffs that affect large numbers of employees. All right, and then risk management is going to be on the Hive. So take a look for that on the Hive. Okay, so now let's move into safety. So here we are going to talk about the premise and requirements of OSHA. We're going to talk about the essentials of creating and maintaining a safe environment, and then we'll talk about imminent danger. All right, so given the responsibility for people, culture, and associated policies and procedures, HR plays a critical role in supporting workplace health and safety. So workplace safety is a process that seeks to eliminate or reduce risks of injury or illness to employees. Now, the chief aim of workplace safety is to protect an organization's most valuable asset, its people. Workplace safety is achieved through a variety of methods, including policies, procedures, and specific hazard control techniques. So we talk about OSHA. So OSHA was created as an administrative agency to provide workers, to give them protection, and in most instances provide state approved job safety and health plans. So its main goal was to ensure that employers provide employees with an environment free from recognized hazards like exposure to toxic chemicals, excessive noise levels, mechanical dangers, heat or cold stress, and unsanitary conditions. So a lot of states do have their own OSHA administrative agency, which the federal agency, obviously the federal government allows that to happen. The caveat there is that the regulations on the state level need to be as strict, if you will, as on the federal level, or stricter in order for the state agency to maintain its level of enforcement of safety. The OSHA General Standard. So the OSHA General Standard is one that's enforced. That's kind of like the guiding, I guess, mission, if you will, of OSHA. And what it says is that the employer will furnish each of its employees employment and a place of employment that are free from recognized hazards that are causing or are likely to cause death or serious physical harm to its employees, and that it shall comply with occupational safety and health standards under this particular chapter. So that's an important thing to know, that is the general duty clause, and all employers are required to abide by that. Incident rates. So the Bureau of Labor Statistics compiles incident rates for occupational injuries and illnesses from employee reports required by OSHA. And the formula that we see here on this slide is used to calculate incident rates. And it's calculated as N being the number of injuries or illnesses or lost work days. EH represents the total employee hours worked by all employees during the calendar year. And then that number 200,000 is equivalent to 100 full-time employees working 50 weeks at 40 hours per week. And that's a number that OSHA actually developed. That's kind of like their benchmark or standard that they use. And OSHA also outlines workers' rights. So employees have the right to request an OSHA inspection if they believe that their job duties or working conditions pose a threat to their well-being. OSHA protects employees from discharge or discrimination when they report unsafe or unhealthy working conditions, regardless of whether they report the complaint to the employer, OSHA, or outside parties like the press. Additionally, employees have the right to participate in union activities related to job safety, for example, serving on a safety committee. Employees or their representatives have the right to participate in OSHA inspections, conferences, and hearings, and employees have the right to refuse to work if they reasonably believe that their working conditions pose an imminent risk of death or serious bodily injury. There are some record-keeping requirements, so all employers must report any accident that results in the death of an employee or inpatient hospitalization of 3 or more employees to the nearest OSHA office within 8 hours. And let's talk about those reports. So these are the OSHA forms, the 301, the 300, 300A. And I'm going to show you a little bit more about what those look like in a couple seconds here. So employers with 11 or more employees must maintain the 300, which is a log and summary of occupational injuries and illnesses, and that's used to document recordable occupational injuries or illnesses within 6 days after discovery of the incident, and must be maintained on a calendar basis, so January 1st to December 31st. And the Form 301 is a supplemental record of occupational injuries or illnesses, and that provides detailed information on the recordable incidents and must be available for inspection. So employers may substitute workers' compensation insurance or forms that are similar like that, but the thing to remember here is that it needs to contain all the information that's required by OSHA, or if the employer adds the missing information. So then the other thing that comes up, and this is not a typo, is that the employer needs to keep employee medical records. They must be kept for the duration of the employee's tenure with the company plus 30 years. All right, so here's a snippet of what the 301 looks like. So you can see that this is the form that captures the specific employee information and their injury or illness. The 300 is the cumulative log that the employer needs to keep of the injuries that took place within the organization. And then this is the 300A is the log that needs to be posted. So employers are required to post this on an annual basis from February 1st until April 30th. It needs to be posted in a place where all employees have access to it and can view it. Okay, so let's talk about OSHA inspections. So the inspection begins when OSHA arrives at the workplace. OSHA inspectors look for hazards, or they look for violations, but some kind of grab more attention than others. So things like scaffolding, fall protection, hazard communication, lockout, tagout, respiratory problems, those are some of the frequent inspections that receive violations. And then what happens in terms of the process is that the on-site visit will take place. It's conducted without advance notice. Inspectors can walk into a place of employment and request that you permit an inspection, so you don't have to agree unless the inspector has a search warrant. In the absence of a warrant, the employer can delay the inspection until an attorney is present. On-site inspections usually follow they usually ask for a representative, an employee representative to accompany them, and then they will go through and check for any type of violations. And if they see violations, they will issue a citation. The inspection priorities. So OSHA enforces its standard through inspection. So the inspection, like I said, is usually unannounced. There is a precedent that OSHA takes in terms of the first approach in setting inspection priorities. So priorities include from highest to lowest: imminent dangers, catastrophes, and fatal accidents, employee complaints, high hazard industry inspections, and follow-up inspections. And OSHA conducts inspection within 24 hours when a complaint indicates an immediate danger, and within 3 working days when a serious hazard exists. So for a non-serious complaint filed in writing by an employee or a union, OSHA will respond within 20 working days. OSHA handles other non-serious complaints by writing to the employer and requesting corrective action. All right, so let's test our knowledge here. Let's see if I have a poll for this one. Hang on a minute while I launch that. All right, so during the, should be opening, sorry for the typo, during the opening conference of a site inspection, the OSHA compliance officer will request an employee to accompany them during the facility tour. What happens if no one volunteers? The inspection will not continue. The company will be fined. The OSHA compliance officer will interview employees, or the company will receive a reprimand. Okay, and the answer here, let me stop the poll. The answer here is C. So if no employees volunteer to accompany the officer on their tour, then they will interview employees about their working conditions. It's a standard procedure for the officer to be escorted by an employee, but if this is impossible, then the officer continues the inspection in the most effective way possible, and the company won't be penalized for failing to provide an escort. Okay, let's go to the next knowledge check. Okay, it looks like I don't have, well, maybe I do. Let me check. Okay, there we go. Yep. Which of these work-related injuries would need to be, excuse me, would need to be recorded? Is that a paper cut that bleeds through to require a band or bleeds enough to require a Band-Aid, a sprained ankle that needs to be wrapped, a needle stick from a needle that has been in contact with another person's blood, or a splinter that is removed by a company nurse? Okay, the answer here is C. So work-related injuries and illnesses must be recorded if they involve any needle stick injury or cut from a sharp object that is contaminated with another person's blood or other potentially infectious material. All right, so let's talk about hazard elimination. So elimination is the process of removing the hazard from the workplace. It's the most effective way to control a risk because the hazard is no longer present. So OSHA specifies a three-step standard for creating a safe environment. The first one is using engineering controls, and that would be to make changes to the work environment, like a machine or a piece of equipment, often reducing the hazard at the source. It would be to follow safe work practices and avoid accidents, and then obviously using personal protective equipment like safety glasses, hard hats, things like that. Okay, so OSHA is authorized to conduct workplace inspections to enforce its standards. Kind of talked a little bit about this, but they do that based on what type of situation is taking place. So if they have reason to know that there's imminent danger, if there's a fatality or a catastrophe, or if there's an employee that complained, that's when they would do a inspection outside of like a rotation. And then the question comes up a lot of times is what exactly is imminent danger? So an imminent danger or an imminent complaint is one alleging that any condition or practice in a place of employment constitutes a hazard, which could reasonably be expected to cause death or serious physical harm immediately or on or before the imminence of the hazard can be eliminated through OSHA enforcement practices. So 3 conditions must be met for a hazard to become imminent. One, there must be a threat of death or serious physical harm. So serious physical harm means that a part of the body is damaged so severely that it cannot be used or cannot be used very well. Number 2 is for a health hazard. There must be a reasonable expectation that toxic substances are present and exposure to them will shorten life or cause significant reduction in physical or mental efficiency. And then number 3 is the threat must be imminent or immediate. So that means that there's a belief that death or serious physical harm could occur within a short time. Okay, so next knowledge check. So which of the following statements is true about OSHA inspections? Is it that they are announced at least 24 hours beforehand? Employers can require OSHA to have a search warrant. OSHA inspects every establishment every 3 years, or OSHA is not required to protect trade secrets discovered during an inspection. Okay, I'm going to end the poll, and the answer here is B. So in 1978, the Supreme Court ruled that OSHA may not conduct warrantless inspections without an employer's consent. So the ruling does little to curtail OSHA inspections. However, because OSHA can acquire an authorized search warrant or its equivalent based on administrative probable cause. Okay, so let's talk about criminal penalties for violations. So there are 5 levels of violations under OSHA. So de minimis violations have no relationship between safety and health. An example of that might be a ladder with 13 inches between the rungs rather than 12 inches. Other than serious violations, this is where serious harm is unlikely. So like failure to provide copies of safety regulations and failure to post required documentation of work areas, those are considered other than serious OSHA violations. Serious violations, this is where a high potential for injury or death exists, which is known reasonably or which should have been reasonably known. Failure, so it would result in a failure to ensure that employees who carry heavy loads wear steel-toed boots. That might be an example of a serious violation. Willful violation, that's an intentional disregard. An example might be a fatal crushing accident because the employer did not implement adequate safety procedures for equipment that caused prior crushing injuries. And then repeated violations. So repeated willful violations of a similar nature can be very costly in fines. So penalties of up to $70,000 for each violation, just to give you an example. Excuse me. Hazard communication standards. So while you're performing specific job duties, employees can come into contact with a lot of information about materials. The hazard communication standard requires employers to notify employees when hazardous chemicals are present in the workplace and to train employees on how to work with them safely. So manufacturers, distributors are required to label, tag, or mark every container of hazardous materials. And I don't have a poll for this one, so just go ahead and type this in chat. But material safety data sheets are now referred to as safety data sheets. The M was dropped. How many sections are now part of a safety data sheet? Is it 6, 10, 4, or 16? Okay. Yeah, and the answer is D. So, yep, it is 16. So, material safety data sheets are referred to as safety data sheets. The M has been dropped. More importantly, these safety data sheets must now contain 16 sections in a specific order. And because of these changes, employers should expect to receive updated labels and SDSs with inbound shipments of chemicals. Okay, so let's go to the next one. And again, I don't have a poll for this, so just type in chat. But which of the following are employer responsibilities pertaining to SDS? Is it that SDSs must be acceptable to employees for all hazardous chemicals? SDSs can be available in a binder or on a computer. Employers should consider having a designated employee maintain SDSs, or is it all of the above? Okay, yep. And the answer here is D. So it's all of the above. So employers want to ensure that SDSs are readily accessible to employees for all hazardous chemicals in their workplace. And that may be done in a couple of different ways. So for example, employers may keep the SDSs in a binder or on computers as long as the employees have immediate access to the information without leaving their work area when needed, and a backup is available for rapid access to the SDS in the case of a power outage or other emergency. And furthermore, employers may want to designate a person responsible for obtaining and maintaining the SDS. So if the employer does not have an SDS, the employer designated person should contact the manufacturer to obtain one. Okay, again, another knowledge check here. If you want to go ahead and just type in chat. So which of the following is an example of a chemical health hazard? Is it a bacterium, a pesticide, a fungus, or a virus? Okay, and the answer here is B. So a pesticide is an example of a chemical health hazard. The other three answer choices are biological health hazards. All right, so let's look at safety programs. The four basic elements of OSHA's health and safety program are management commitment and employee involvement, worksite analysis, hazard prevention and control, and safety and health training. So there's a few components that can be incorporated that OSHA recommends for a successful safety management program, and that's to have posters in the workplace, hold meetings, have communication, show employees a copy of the OSHA standards, prepare a policy statement that you have for internally how you're going to handle safety, include job safety topics and conversations, review inspection, accident reports, and participate in labor management safety committees. All right, for safety training, it's important to involve the workforce in developing implementing and optimizing the training program. You want to create training and testing procedures that can be applied in roles throughout the organization. Train managers, include communication channels for reporting hazards in the work area. Test your employees. Provide continuous and easy access to safety training content. Have a company safety policy. Okay. Not going to go in a ton of detail on this, but there are partnerships and cooperative programs. So the biggest takeaway for this slide is just to understand that there are various programs that OSHA has partnered with employers on, and that employers have the ability to participate in these programs. The overall theme with these programs is that they show the employer has the ability to show their commitment to safety when they participate in these programs, any one of these. The very last one, the sharp one over there on the right, that's the one that has various levels to it. So the higher advanced levels that an employer gets to in terms of meeting like safety criteria and showing their commitment to safety means that they would in some instances have the ability to forego OSHA inspections just because they've proven that they have a safety plan in place. So like OSHA Challenge is a 3-step process. It's led by OSHA administration. The alliance or cooperatives between a company and OSHA. The strategic partnership is voluntary. It's a long-term agreement with OSHA, and then that involves a group of employers. The voluntary protection program, and again, all of these are voluntary. There's no mandate or requirement that employers have to participate in these. So when an employer goes above, it's kind of showing that they're going above and beyond and taking the initiative to do extra things mandated by OSHA to ensure that they remain safe and compliant. Okay, don't have a knowledge check or poll for this one, so type in chat there if you would. So which of the following is not one of the elements of a good safety program? Is it identification and control of hazards? Is it keeping information about accidents and injuries confidential? Is it the assignment of responsibilities to key executives, or is it employee awareness and acceptance? Okay. So the answer here is B. So to help organizations, especially small businesses, comply with its regulations, OSHA recommends a 4-point safety program. These 4 points include management commitment and employee involvement, worksite analysis, hazard prevention and control, training for employees, supervisors, and managers. OSHA claims that this approach does not require additional employees or large costs and that it can be easily integrated into other business functions. Okay, so let's move on and talk about accident investigations. So the term accident is often used when referring to an unplanned, unwanted event. Since nearly all worksite fatalities, injuries, and illnesses are preventable, it is the goal of every accident investigation to identify and correct the root cause. The focus shouldn't be on finding fault or blame. By doing so, that will, that'll create situations or by not focusing on blame, that helps to focus on keeping morale high and increased productivity, allowing employers to demonstrate their commitment to safe and healthy working environments. Most importantly, it enables employers and employees to identify and implement the corrective actions necessary to prevent future incidents. So anyone who witnessed an accident should be interviewed as well to learn about what they saw and what happened. We talked a little bit about drug-free workplace, but good faith is a component that I'm not sure that we covered. So good faith, the question comes, is it an obligation that employers require drug testing? No. What that means is that employers are developing policies, procedures, and practices to ensure workplaces are free of drug use. So the Work-Free Drug Place Act, it established that employers need to create a drug-free workplace policy for all contractors, federal contractors, and federal grantees, and distribute copies of that plan to all employees that are covered by it. They need to formulate a drug-free awareness campaign. They need to require employees to abide by the policy terms and inform the company in case of drug-related crimes committed by the employee. And while private corporations may have no plans of entering into federal contracts or grants, they're not required to comply by law, but they are certainly free to establish drug-free workplace policy. All right, so we talk about workers' compensation. So when employees are injured at work, not only is their health affected, but they may be left to perform their job duties, unable to perform their job duties, and possibly with some pretty significant medical bills. So workers' compensation provides income continuation and reimbursement of accident expenses. There are some common law defenses. There's the assumption of risk, which allows the employer to be held harmless to the extent that the injured employee voluntarily accepted the risks associated with the work. The fellow servant doctrine is that the employer can be held harmless to the extent that the injury was caused in whole or in part by a peer of the injured worker. And then the contributory negligence allows an employer to be held harmless to the extent that the injured employee failed to use adequate precautions required by ordinary prudence. Okay, so if we look at return to work programs, the benefits of return to work, sometimes referred to as light duty programs, include a productive workforce, reduced costs due to overtime, and then reduced administrative costs. So the thing to keep in mind that if an employer adopts a light duty program for employees with work-related injuries, it may be required to offer light duty as an accommodation to employees whose disabilities are not work-related. So the EEOC has taken the position that an employer that reserves dedicated light duty positions for employees with occupational injuries is also required to resign or reassign an employee with a non-occupational disability to a vacant reserved light duty position as a reasonable accommodation for which they're qualified to do that. Okay, and then the knowledge check. So just go ahead and type in chat. A company's workers' compensation costs are determined by the company's, unionization status, wage and salary levels, annual revenues, or experience rating. Okay, and the answer here is D, experience rating. So workers' compensation costs to a company are determined by its experience rating, which is based on the number of payments made under workers' compensation to the employees of that company. Okay, so let's move on and talk about health. So here we're going to talk about best practices. We're going to talk about why we analyze the benefit of healthy employees, and we're going to focus on OSHA standards for maintaining a healthy environment. So well-being programs are pretty popular. They started out as employee perks for large corporations, kind of like fitness centers. Today, well-being programs are common amongst both medium and small-sized businesses, and well-being programs are now regularly part of a company's benefit package. Employee assistance programs, I think we talked about this a little bit, but an employee assistance program at the most basic level is an employee benefit. And the focus or the aim of an EAP is to provide the employees with the help of things like professional counseling, stress management, support services, things like that. So an EAP is a work-based intervention program. It identifies and assists employees in resolving personal problems that may be adversely affecting their work performance. The EAP must be accessible 24/7, and it must be available to all employees and their family members. Yeah, and some have good points. Some have legal assistance too. That's correct. Okay, another health-related service that most employers offer today is an employee wellness program. There's varying forms of wellness programs that can be found in over 80% of U.S. companies. Wellness programs are designed to offer preventative care services that encourage employees to adopt healthy lifestyles and proactively manage chronic diseases like diabetes. They can include weight management, cessation, smoking cessation programs, things like that. All right, so let's test our knowledge here. My employer recently adopted a workplace wellness program. They offer rewards for participating in various activities and meeting different health goals. The first step is completing a health screening assessment, which includes answering questions about the employees and the family's medical history and taking basic medical tests like a cholesterol and blood pressure test. The employee says that they don't want to participate. They feel like their health and their family's health are private, and they have no interest in offering up a bunch of personal information in exchange for $50. Can the employer require the employee to participate? Okay, that is correct. No, they cannot require you to participate in their medical screening. Two federal laws, the Americans with Disabilities Act and Genetic Information Non-Discrimination Act, strictly limit an employer's right to collect or require employees to provide medical information. And both laws also require employers to keep employee medical history and information confidential. Okay, next knowledge check. Which of the following is true about employee assistance programs? Is it that the program should be accessible from 9 to 5 or during all regular business hours? Is it that all problems and conditions reported by the EAP should be reported to management and to the employee's supervisor? Plan participants should be required to meet with EAP staff at the EAP office, or the program should be open to all employees and family members. Okay, the answer is D. Employee assistance programs should be open to all employees and family members. And some problems like marital conflicts or runaway children require the involvement of other family members to solve them effectively. Okay, so let's talk about the Patient Protection and Affordable Care Act. and wellness programs. So an employer may offer its employees a financial incentive for participating in its wellness program as long as the employer doesn't discriminate based on an individual's health-related factors and the program meets specific requirements. So you can see here there are 5 requirements that must be met to satisfy the Affordable Care Act incentive program. Reasonable accommodations must be provided absent undue hardship to enable employees with disabilities to earn whatever financial incentive an employer offers as part of its wellness program. An employer that offers employees a financial incentive to attend, let's say, for example, a nutrition class, regardless of whether they reach a healthy weight as a result, would have to provide a sign language interpreter so that an employee who is deaf and who needs an interpreter to understand the information communicated in the class could earn that incentive as well, as long as providing the interpreter would not result in undue hardship to the employer. So for health contingent programs, every employee must be given the opportunity to earn the full reward regardless of their personal health status. The ACA requires employers to offer a reasonable alternative to any individual who fails to meet the requirements for a reward. So for example, activity only, let's say a doctor may verify that it's medically inadvisable for an employee to participate in an activity due to an illness. The employer may waive the activity requirement or offer the employer a reasonable alternative activity to earn the full reward. Okay, so let's talk about blood-borne pathogen standards. OSHA mandates employers who have employees at risk of occupational exposure adhere to a blood-borne pathogen standard. So they need to do the things that are listed on the slide, develop a written plan, minimum exposure risk by having engineering controls like personal protective equipment, assure vaccination, inform employees of the hazards, and maintain medical records of employees. Okay, so we're all probably pretty familiar with this term, pandemic, right? So the book talks a little bit about an epidemic. So an epidemic refers to a sudden increase in the number of cases of a disease above what's normally expected. A pandemic refers to an epidemic that has spread over several countries or continents, usually affecting a larger number of people. So we all know HR's response to that, workforce or remote work policies, onboarding remotely, having policies for employees who are sick, screening employees, having leave policies, and then obviously following the CDC guidelines. Toxic substances. OSHA recognizes that employee health can also be affected by toxic and hazardous substances in the workplace and have issued regulations regarding their use. So employers must adhere fully to these regulations and train all employees in the safe handling of the substances as well as general health and safety training. So when educating employees, an employer must identify and share certain information regarding exposure levels. The no adverse effect level identifies the highest dose or exposure amount that would cause no ill effects in an employee. Think of like disinfecting wipes and hand sanitizer. They're toxic, but when applied or taken as recommended, they don't have any ill effects on people. And then we talk about the toxicity threshold. This measurement demonstrates the lowest dose or exposure amount for which toxic effects can be observed. So like years ago, I worked for a paint spray manufacturing company, and they had a spray booth, and we came out and tested the air quality, and it came back that the air quality was within the level or threshold of being acceptable and not toxic to the employees who worked in that spray paint booth. So mental health. Question comes in, can an employee receive workers' compensation for a physical or mental breakdown? And the answer to that question is yes, if they have cumulative trauma from excessive stress on their job. So, boredom, challenges to good health or boredom, burnout. So this is where it's a special type of work-related stress, a state of physical or emotional exhaustion that involves a sense of reduced accomplishment. It could be anxiety, which is refers to stress caused by work that leads to anxiety or the impact of an anxiety disorder at work. And then it could be depression, which is intense sadness. We talk a little bit about continuing on with mental health. Um, there's something called the general adaptation syndrome, which has a couple of different phases associated with it. The first is the alarm reaction, which is where you have a response to a stressor, and that is recognized. And the nervous system prepares the body for physical action. So that's the fight or flight response. The resistance stage, so after the threat has passed, the body begins returning to a state of equilibrium. And even if the stressor is still present, the body tries to regain balance. And then the exhaustion stage. So this is when the stressor continues, the body exhausts its ability to adapt, wear and tear results, and then this is where things get pretty significant or severe. Some employers have what's considered to be an on-site medical clinic. Many large companies provide on-site medical care as a win-win. There's also other models. There could be vendor managed, which is clinics are contracted out to third-party vendors. Or there could be, where the organization contracts directly with healthcare professionals, or it could be employer managed, where they operate the center themselves. Okay, so let's go to the next knowledge check here. The fight or flight response refers to, is it the ambivalence people feel when they experience stress, the difficulty people experience in making decisions under stress, the physiological changes that occur under stress to prepare the body for action, or the irrational way people tend to respond under stress? Okay, the answer here is C. The alarm reaction has been called the fight or flight response. In this stage, the nervous system makes dozens of immediate responses to prepare the body for physical action. Okay, let's talk about security. So here we are going to focus in on vulnerability analysis. We're going to talk about legislative protections, and we're going to talk about OSHA standards. So organizational security involves the protection of companies' employees, data, company resources, and assets. The responsibility for security belongs with HR in most small and medium-sized companies, and as companies become larger and more vulnerable to threats, they're more likely to establish a separate security or loss prevention department. Vulnerability analysis. So this is gaps in protection. So these are threats that might be the presence of a threat. So if you look at this chart, we have low frequency, low risk, which means that it doesn't really happen very often, and when it does happen, it's not really a big deal in terms of the impact to an organization. So it might be something like every once in a while, maybe somebody leaves like the door open. It doesn't happen very often, and there's not really much risk to the organization if someone comes in, if it's like a office setting. Like I worked in an office where we had the door locked all the time. Every once in a while someone would let somebody in. It wasn't like we had any big confidential protected information. It was just kind of what we did during COVID, and we just carried it over. The next one would be low frequency, high risk. So this would be where it doesn't happen very often, but when it does happen, it does create a significant impact to the organization. So this might be a situation where, I worked for a company where we didn't do educational verifications. And so, there was only one time in the time that I worked for the company, in the years that I was there, that we had someone who lied on their resume and said that they had a degree when they didn't have a degree. High frequency, low risk, that would be things like office supplies. Maybe people taking paper clips. It happens a lot, but there isn't a big financial risk to the organization. And then high frequency, high risk. So that would be where things are happening, have the potential to happen on a regular basis, and then there is a higher risk to the organization because of that. All right, so we talk about liability limits. One of the biggest threats to companies is, theft, because of legal problems associated with searching employees suspected of theft. Companies must use care to develop loss prevention policies. The most common legal problems associated with liability based on employee theft or things like that is false arrest and malicious persecution, assault and battery, invasion of privacy, defamation, false imprisonment. So invasion of privacy would be the intrusion into someone's personal private solitude or seclusion. An employee may allege this form of privacy invasion when an employer unreasonably searches or conducts surveillance in areas in which the employee has a legitimate expectation of privacy, like a restroom or dressing room. The signal detection theory, so controlling the flow of people into and out of a facility, is another way of a company that they can do to reduce the risk of loss while increasing security and protection of assets. So this is a chart that shows the use of a person to monitor the security and safety of a facility. So when we use security personnel, this is what we might see. We might see a situation where we have a hit, where the security officer detected that there was a threat and there was an actual threat. Down at the bottom, we could see a security breach where no action was taken, but there was a threat. We could see up the top where there's a false alarm. They detected a threat, but there wasn't a threat. And then a true miss was where there was no action taken and no threat. Okay, so we are running a little bit behind on time. So for the sake of time, I'm going to just go ahead and go through this and give the answer on these knowledge checks. So according to the signal detection theory, what happens when there is an actual threat and no action taken would be B. That's a security breach. So according to the signal detection theory, when no action is taken, in the event of an actual threat, a security breach occurs. Okay, so next we're going to talk about privacy protection laws. We're going to talk about federal wiretapping, Fair Credit Reporting Act, privacy protection, polygraph, and USA Patriot. So the Federal Wiretapping Act makes it a felony to intentionally intercept any wire, oral, or electronic communication through the use of any electronic, mechanical, or other device. The only exceptions would be that the service provider allows the owner of a communication system to monitor communications. The business use exception allows employers to monitor non-personal telephone calls, and then the recording of one party to the conversation consents. That would be an exception. The Fair Credit Reporting Act offers protection for individuals against negative credit reports containing false or misleading information. The Act applies to employers who purchase consumer reports from consumer reporting agencies. The regulation requires that if an employer decides to take an adverse action based on a consumer report, it must furnish the applicant or employee with a notice of the adverse action taken. All right, and the Privacy Protection Act protects the privacy employees of the federal government and its contractors. The act prohibits government agencies from disclosing records about individuals unless they have permission from the individual or the reason for the request meets some exceptions. The general policy goals are to minimize intrusiveness, to maximize fairness, to create legitimate expectations of confidentiality. The Employee Polygraph Protection Test, otherwise known as lie detector, these tests are used for ongoing investigations, and the test can be used if the tested employee had access to property in question, the employer had reasonable suspicion of the employee's involvement, and the employer provided a statement explaining the basis for suspecting the above conditions. The Patriot Act, which was known as the Freedom Act, it allows an employer to provide information. It eases the restriction on law enforcement agencies in their search of telephone and email communications and medical and financial and other records. So if there is a request for that information, the company is required to notify employees of company obligations to respond to requests. Okay, polygraph testing is legal when the test, actually the answer here, the test is part of an ongoing investigation of losses. Okay, protection of proprietary information. With the common use of computers and internet in the workplace, most companies recognize serious threats to proprietary information and data from hackers, computer viruses, software, and theft. So companies employ a variety of methods to protect an organization's proprietary information. One of them is a firewall. It could be patents, trademarks, copyrights. Crisis management and contingency planning. So part of an employer's obligation to provide a safe and healthy workplace is ensuring that the company has a proactive plan for handling emergencies like fires, explosions, earthquakes, chemical spills, and acts of terrorism. So part of the planning process should outline resource allocations, including information on how employees may be deployed and other areas of the workforce should certain work groups not have the adequate staffing due to illnesses, death, or travel restrictions. So the workforce planning component should identify training needs so that the staff is adequately prepared to take on additional duties in emergencies. And because organizations grow and change over time, they should periodically review and update their emergency plan just to ensure that it's still operational. So emergency preparedness, so there is a growing expectation that companies have some legal obligation for the well-being of their employees and customers, and that liability stems from that general duty clause of OSHA. So standard for emergency preparedness would be to develop a plan, appoint some type of a coordinator, create an advisory committee, conduct a risk assessment, develop that plan, evaluate and modify, and then communicate that plan. Protecting employees abroad. So a lot of times companies are conducting business in dangerous parts of the world. So companies with employees who live in or travel to foreign countries, especially countries with higher levels of terrorist activity or political unrest, must have plans for protecting their employees and family members. So effective security plans should include an assessment of the potential risks, measures to mitigate those risks, and crisis strategies that include plans for emergency medical treatment, including medical evacuation. And a well-developed security plan will also include provisions for dealing with conflict situations like war, terrorist attacks, political upheaval, and plans for responding to natural disasters. Workplace violence. So the topic of workplace violence tends to dominate the news, in a lot of instances. So ways to make sure that you mitigate that would be to have zero tolerance provisions. I also added like this little snippet, talking a little bit about identification of workplace violence, What is it? Is it criminal intent? Is it customer client? Is it a coworker? Is it a personal relationship? And then some of the warning signs on how to identify if an employee has a propensity to create danger in the workplace. So some of the things like increased use of alcoholism, depression, mood swings, suicidal comments, behavior that is seemed to be a little bit paranoia, empathy with individuals committing violence, things like that. Okay, so which of these is best suited to minimize violence in the workplace? And the answer here would be B, avoid disciplining employees in public. So to reduce the likelihood that a disciplinary action will turn violent, managers should avoid disciplining a worker in public. Instead, talk with the worker in private and try to keep the problem in a private manner. Okay, so we talked a little bit before about some companies having a higher risk of theft or fraud. Because of that higher risk, these organizations develop a loss prevention department. Every organization should develop a clearly defined process for handling money within the organization. Employees who recognize a well-written process is in place and observe financial transactions being audited are just less likely to commit acts of theft or fraud against their employer. So under the Federal Sentencing Guidelines for Organizations Act, or FSGO, companies can be criminally responsible for fraud that's perpetrated by their employees. And this law also applies to virtually all U.S. businesses and organizations. It increases corporate penalties for violations of the federal law. Internal financial control, so to ensure that employees do not feel pressured to commit fraud, a company must implement internal fraud controls. So these controls are intended to ensure no one person has the ability to steal money from the employer. And a well-developed system has appropriate checks and balances and requires a high level of visibility for financial transactions and auditing of work related to those transactions. So examples of financial controls might include putting spending limits on spending. There should be 2 levels of approval on financial transactions above a dollar amount. Anti-fraud and the FSGO. So in addition to creating internal financial controls, an employer should also implement an effective anti-fraud program to avoid being responsible for the criminal acts of employees and to limit the ability of employees to commit theft or fraud. So under the Fair Sentencing Guidelines for Organization Act, companies can be criminally responsible for fraud committed by their employees. So it's important that companies put measures in place to minimize risk and to decrease the opportunities for fraud to happen. So reporting, employees should have a method for procedure for reporting fraud, like a hotline. Oversight, prudence through background checks and trying to minimize exposure for hiring employees with fraudulent backgrounds. Communication, training, and having employees acknowledge code of conduct and ethics training, compliance, enforcement, which means discipline and consequences for those who fail to report violations, and then prevention. Okay, so investigations of fraud that involve senior management should be conducted by, that would be outside investigators. So recommendations for investigating internal fraud and thefts include using an outside investigator when allegations involve senior management or the crime involves advanced technology like computer security or network hacking. Okay, so I know I went through that a little bit fast, but that is the end of Unit 5. So we have a bit of time to spend on review. So this is just a slide that talks a little bit about reminders for exam day, just the ABCs, believe you can succeed, breathing, it matters more than you think, and then expect success, so have confidence. Okay, the first part of the review is going to cover units 1, 2, and 3. And these are multiple choice, responses. So feel free to type in chat if you'd like, if you feel comfortable doing that. I'll give you a second to review the answers to this one. But the first question that we have here is affirmative action plans were formally established by, was it the civil rights leaders under the leadership of Dr. Martin Luther King? Was it the Supreme Court 1970 ruling in Griggs versus Duke Power? Was it Title VII of the 1964 Civil Rights Act, or was it Executive Order 11246 issued by President Lyndon Johnson? Okay. Yep, it is D. The answer is D. So the executive order that has the greatest impact on reducing racial discrimination is Executive Order 11246. The order not only prohibits racial discrimination, it also requires contractors and their first tier subcontractors to develop written affirmative action plans and to establish goals and timelines for achieving them. Okay, 65-year-old workers can be forced to retire if they are overqualified for the job, are eligible for retirement benefits, are highly compensated, are top level executives. Okay, the answer here is D. The AD, the Age Discrimination and Employment Act, expressly excludes executives and high policy-making employees from coverage, allowing these employees to be forced into retirement at age 65. So for this exemption to apply, however, the executive must have held the position for 2 years or more preceding retirement and must be entitled to retirement income on an annual basis. Okay, so we have an ice cream company that has vendor criteria for the humane treatment of dairy cows is practicing what? Is it compliance with the FDA, food safety standards, social responsibility, or corporate governance? Okay. And the answer here is social responsibility. Social responsibility focuses company efforts on practices that do no harm or that positively affect the customers and communities where they live and work. So by contrast, corporate governance is the balancing of the needs of the stakeholders affected by business practices. Okay. A restaurant institutes a new happy hour as a marketing campaign. A year later, the owner wants to know if sales have improved as a result of the campaign. Comparing sales from the previous year to the current year is an example of using which type of strategic planning metric? Is it gross profit margin? Is it opportunity success rate? Is it innovation rate? Or is it return on investment? Yeah, this one was a little trickier. So the answer here is A. So the gross profit margin is the total revenue for a certain period minus the cost of sales for that period divided by total revenue for that period. So comparing the gross profit margin for the two periods is helpful when you're determining if a new campaign is increasing sales or if a new strategy is needed. Okay, which of the following act requires federal contractors or subcontractors with contracts of $25,000 or more to list all non-senior management job openings with state employment agencies? Is that the Rehabilitation Act of 1973, the Executive Order 11375, Executive Order 11246, the Vietnam Era Veterans Readjustment Assistance Act of 1974? Okay, the answer here is actually D. So state employment agencies are required under VIVRA, which is the Vietnam Era Veterans Readjustment Assistance Act to give priority to Vietnam era veterans when providing referrals to job openings. The act further requires that contractors and subcontractors meet criteria or meeting certain criteria, list all job openings with the same state agencies. Okay, someone's asking me to go back, so let me go back to the previous. Okay, so the answer here was A, gross profit margin. The gross profit margin is the total revenue for a certain period minus the cost of sales for that period divided by total revenue for that period. So what we're doing is we're comparing the gross profit margin for the two periods, and that's helpful in determining if the new campaign is increasing sales or if a new strategy is needed. Okay, yep, you're welcome. Okay, so William is creating a manual for his department. On the cover of the manual, he uses a picture of the equipment that he found on a website. So you ask if he has permission to use the image. He tells you that the photo is from a website, so it's in the public domain. Are photos and images from websites considered to be in the public domain? Would you say, yep, all images on the internet are in the public domain? No, images are protected by copyright laws. Yes, copyright does not apply to the internet, or no, images are protected by creative rights. Okay, the answer is B. So creative works are not protected by intellectual property laws, such as copyright and trademark protection, are said to be in the public domain. Works become public when the owner fails to acquire copyright or trademark protection because of a lack of filing or renewal of a copyright or trademark with the government. The rights have expired, the type of work may not be protectable, or the owner may intentionally allow public use. So if an owner does have copyright or trademark protection, the work is not in the public domain and cannot be used without the permission of the owner. So websites have different policies on the use of their content. Some may offer the rights to use their images for payment, while others allow users to use their images for free. Okay, Mary Jones is a full-time employee who has worked for a nationwide car manufacturer for more than 15 years. She needs time off of work to care for her child, who has recently been diagnosed with asthma. Which of the following steps should you take first? Would it be to notify her supervisor that she'll be off work, verify her eligibility for Family Medical Leave Act, call a staffing agency to find a replacement for her to train before she's off, or request medical certification from her child's doctor? Okay, the answer here is B. So by verifying that Mary is eligible for Family Medical Leave Act, you're ensuring that her rights are protected and that you comply with the standard if required. So after you have verified her eligibility, you may request medical certification from her physician and work with the supervisor to determine replacement needs and sources. Okay, which leadership concept uses concern for people and concern for production as measurements to determine quality leadership? So this is the leadership grid, and that's the situational theory that uses that 9 levels, with 1-1 representing the leader who does not care about people or production. This extreme represents the worst kind of manager. At the other end of the spectrum, the 9-9 represents a leader who shows equal concern for people in production. Okay, mergers and acquisitions provide HR with special problems of cultural differences in order to make sure that the culture doesn't clash, that the cultures don't clash after the merger. HR should assign a subordinate to monitor the complaint levels and report on problems that are being addressed, conduct meetings with key players from each organization to outline the cultural values of each organization, determine how best to protect them in the blended employer unit, send memos to department heads to specify the new cultural characteristics and express the expectation that department heads will make it happen, or provide written complaint forms to all employees and express a willingness to listen to any comments the employees have to make about the merger. Okay, and the answer here is B. So involving those key players is a proactive approach and can provide a strong foundation for developing a new blended culture. All right, it's time for your company to complete its annual budget. This year, the CFO announces that this will be a zero-based budget. In building the HR budget this year, you would account for which of the following rationales. Expenditures are made upward or downward to the existing budget based on return on investment. All expenditures, whether increased or decreased, must be rejustified for each new budget period. Any increased or new expenditures are strictly prohibited, yielding no budget change, or adjustments are all carefully evaluated and approved so that there are zero risks. Okay, the answer here is B. So zero-based budgeting refers to all expenditures, increased and decreased, being rejustified each budget period. Okay, the retail restaurant for which you are a regional HR manager is dependent upon low wage workers for their entry-level positions. For this reason, there is a high turnover. This is the best example. Which of the following SWOT elements? Is it strengths, weaknesses, opportunities, threats? Okay, and the answer here is B. So low paying wages resulting in high turnover is an internal weakness that affects an organization's ability to compete. Okay, an HR manager must forecast HR needs for the upcoming 5 years as part of her strategic plan. What would be the best action to start to project future HR needs? Okay, a trend analysis. So completing a trend analysis will give her the most systematic view so she can develop an appropriate projection plan. Okay, so a company is a federal contractor. It maintains and monitors an affirmative action plan. Upon analysis of the affirmative action plan, it's discovered that minorities are underrepresented in technical job classifications. What key step would you take to influence this issue? Yeah, once a business realizes minorities are underrepresented in specific job classifications, the best strategy is to implement a diversity outreach recruitment plan. And that would entail attending job fairs, advertising in diversity publications, or recruiting from schools that rank high in diversity publications or populations, rather. Okay, the motivation theory that suggests people are motivated by the reward they receive when they succeed and that they'll weigh the value of the anticipated reward against the effort required to achieve it is known as what? Is it Vroom's expectancy theory, Adams' equity theory, McClelland's acquired needs theory, or McGregor's theory X and theory Y? Okay. And the answer here is A. So Vroom explains the theory that with three terms: expectancy, so the individual's assessment of their ability to achieve the goal; instrumentality, whether the individuals believe they are capable of achieving the goal; and valence, whether the anticipated goal is worth the effort required to achieve it. Okay, the purpose of an HR audit is to improve HR effectiveness, improve employee morale, analyze policies, programs, and procedures to ensure legal compliance, or all of the above. Okay. Yeah, it's a D, all of the above. So an HR audit is an organized process designed to identify key aspects of HR in the organization, like employee morale, policies, and programs. Okay, so this is Unit 4. Which consideration is important when designing incentive programs with rewards based on improvements in work group productivity? Is it level of cooperativeness in the workplace? Is it the proportion of an individual salary that's linked to variable pay? Is it the value of the incentive relative to employee stock options? Or is it the extent to which the incentive program significantly affects profits? And the answer here is A. So when we're talking about group incentive plans, we're talking about cooperativeness, how well they're working together. Okay, this is Unit 4 and 5. The Stanley Corporation wants to avoid lawsuits, so the Human Resources Department occasionally reviews the hiring process to ensure compliance with all equal employment regulations. This is an example of risk avoidance, risk elimination, risk mitigation, risk transfer. This is actually C. So this is an example of risk mitigation. The Stanley Corporation minimizes the potential for lawsuits by monitoring its own compliance. Some risk cannot be entirely avoided. There's no perfect strategy for avoiding litigation. This risk cannot be eliminated. So risk transfer, on the other hand, is similar to risk mitigation, but it involves increasing expense in one area to minimize a risk elsewhere. So for instance, a company might increase insurance payments to account for a particular risk. Yeah, I can put these on the slide on the high for you. Yeah. Okay, Unit 5. A new employee is told by her coworkers that one of her duties is to handle customer queries as they arrive. However, her superior informs her that customer queries are to be handled by her department as a whole, and in fact, she should defer to her coworkers until she becomes more acclimated. This employee situation can be defined as: is it role orientation, role conflict, role overload, or role ambiguity? Okay, this is actually role conflict. The situation above can be identified as role conflict. So role conflict exists when an employee does not understand exactly what is expected of them. The problem is common when an employee must report to more than one supervisor. Role orientation is the process of becoming familiar with an employee role. Role overload is a sense of anxiety or panic produced by a perception that one is being asked to do too much. Role ambiguity is a general lack of clarity regarding the parameters of the employee role. Okay, Okay, of the following acts, which one requires that companies with federal construction contracts pay their laborers and mechanics the standard wage of employees in the geographic area in which the work is being performed? Is it the Fair Labor Standards Act? Is it the McNamara-O'Hara Service Act? Is it the Federal Labor Relations Act or the Davis-Bacon Act? Okay, and it is the Davis-Bacon Act. So it's also known as the prevailing wage law. It requires that bidding contractors and subcontractors must pay minimum wages to workers who provide work on public or federal work projects. Okay, what act requires all government contractors with contractors exceeding $10,000, non-construction, to pay their employees the real prevailing wage for their locality as established by the Secretary of Labor? Is it the Service Contract Act? Is it the Walsh-Healy Public Contracts Act? Is it the Fair Labor Standards Act? Or is it the Davis-Bacon? So it is the Walsh-Healy. So it's the federal law that protects employees of government contractors um, with holdings over $10,000. So under the act, which was part of the New Deal, the employees were guaranteed overtime if they worked more than 8 hours a day or 30 hours a week. During the union organizing process, how is a bargaining unit determined? Is it by the union organizers, jointly by the union and the employer, by the National Labor Relations Board, or by the employees during the election? So it is the National Labor Relations Board, the NLRB, which determines which jobs will be included in the bargaining unit based on factors like geography, job categories, things like that. Okay, as an HR leader of an organization, you'll be responsible for designing the executive compensation strategy. Which of the following is the best strategic focus of executive compensation design? Would it be to establish shareholder goal alignment, profitability, and long-term orientation? Structure executive compensation in a way that it avoids media attention? Build a communication plan that helps employees accept pay disparity concerns? Or create a plan that can be reviewed and approved by the CEO annually? Oops, sorry about that. Okay, yeah, it should be the answer is A here. So a strategic focus of an executive compensation plan should center around shareholder goal alignment as well as focusing on profits and long-term orientation. So investors are becoming increasingly focused on executive pay and how closely aligned it is to performance. So these key strategic ingredients to an effective executive compensation plan. Okay, an automotive manufacturing plant wants to determine which technology upgrade would increase production efficiency It is preferred that the employees doing the work provide feedback. Which of the following employee involvement strategies would work best? Employee management committees, self-directed work teams, task force, or committees? Okay, and the answer is C. So a task force is formed to recommend solutions to a specific problem. So task forces are disbanded once the problem is solved. Okay, in the expectancy theory of motivation, expectancy is best viewed as a subjective probability, an inherent drive, a source satisfaction, or an unfulfilled need. Okay, the answer is actually A. So expectancy refers to the probability that effort will lead to performance. In other words, if I try really hard, can I do this job? If I exert enough effort, can I perform well? This relationship is viewed as a probability, and in research on expectancy theory, individuals are asked to estimate the perceived probability that a certain level of effort will achieve a particular level of performance. Oh, okay. I see a question. Yeah, go ahead. Okay. Okay, I'm going to go ahead and continue on. Oh. Yeah, take yourself off mute. Okay, so I'm going to go ahead and continue on just for a couple more minutes here because I do have a few more. Feel free to stay on if you like, or you can hop off. So measuring how much a job is worth is known as, is it job analysis, job evaluation, job grading, or job ranking? Okay. The answer here is B. So it is job evaluation, measuring how much a job is worth is known as job evaluation. So job analysis, on the other hand, is a study of the major tasks and responsibilities of jobs to determine their importance in relation to other jobs in a company. Job grading is a means of determining different job levels and pay scales based on the required knowledge, skills, and abilities. And then job ranking compares jobs to each other on their importance to the organization. Okay. Under the Healthy Premium Plan, workers would receive a bonus if they completed a job faster than the standard time, their quality was judged to be superior, their sales exceeded the daily sales quota, or they produced more units than expected. Okay, the answer here is it's actually A. With the Healthy Premium Plan, the workers receive a guaranteed hourly rate plus a percentage, usually 33%, that's kind of the recommendation, of the wage of any time that was saved. Okay, which of the following is described in the statement below? If an employee is called by the employer for work and there is no work available, the employer may be required by state law or employment agreements to pay for a minimum number of hours of work. Is that reporting pay, hazard pay, gross pay, or base pay? Yep, and the answer here is A. So if an employee is called by the employer for work and there's no work available, then the employer may be required by state law or employment agreements to pay for a minimum number of hours of work. So this is known as reporting pay. Hazard pay is additional pay for working in dangerous conditions. Gross pay is the amount earned by an employee before taxes. And then base pay is the foundation of an employer's compensation program. It reflects the value placed on individual jobs by the organization. Okay, a company is experiencing issues with employee attendance on Mondays and Fridays. Which pay for performance strategy is most likely to help the problem? Would it be to make a component of pay for performance tied to attendance, discipline employees who violate the attendance policy, reduce the team-based incentive for groups with less than perfect attendance, or eliminate gain sharing as a possible option until overall attendance improves? We want to go with A here. Transparency and clear expectations are going to be critical to successful pay for performance systems. So an environment with narrowly focused attendance problems like high absenteeism on Mondays or Fridays, the issues are best addressed through direct and honest communication or action. Okay, an employee was terminated because she was talking with her coworkers about trying to get pregnant. The employer told her that she was separating under the at-will doctrine of employment. To challenge the separation in court, which of the following exemption to at-will employment most likely will the employee use? Is it contract, statutory, public policy, duty of good faith, and fair dealing? Now, this one we really didn't get into, but it's actually B. The statutory exemption to at-will employment protects employees from being terminated for a discriminatory reason as set forth in the equal opportunity legislation. Okay. Which law states the statute of limitations on pay discrimination lawsuits resets as each alleged discriminatory paycheck is issued? We talked about it briefly, and maybe we didn't talk about it in compensation, but the answer here is the Lilly Ledbetter Fair Pay Act. Okay. All right, so I'm going to go ahead and I'm way over here on time, guys, so I'm going to go ahead and close this out for tonight. So I want to thank you all and wish you all the best of luck on your exam. I know that the time, you spent a lot of time and effort and attention on your studies. So I appreciate that and the interaction that we've had in this class. So please feel free to stay in touch with me. HR can be one of those places that can feel a little bit, it's always nice to have somebody to lean on for best practices. So feel free to reach out to me on LinkedIn and keep in touch with me. And then, of course, let me know how you do on the exam. We always love to hear some feedback. Any feedback that you could share with me, we pass along to learners in the future. So that helps kind of pay it forward, if you will. So you guys have been fantastic. I know you will do great. I'll hang on a little bit longer if anybody has any questions. I see a question that came up in chat, and I'll definitely address that. Also, keep in mind that you will have access to all of the course materials for 2 years from the day that the class started. And I think we started back in October. I want to say it was the middle of October, which means that you'll have access to everything in the Hive, all of the recordings, all of the practice tests, all the tutorials, all of the coaches' corners, all of that information you'll have access to. I see the question here says, does the 80% pass rate for the pre-test in HRCP for the money back guarantee and also for the second? Okay, so completing the pre-test. So no, you don't have to complete the pre-test in the HRCP, those exams. That's not part of the money back guarantee requirement. So the pre-test does not count, so don't worry about that. So all the other tests minus the pre-test do count. And let me see here. And also for the second chance insurance. So no, the second chance insurance is not part of the money back guarantee, so you don't have to be concerned about that. So yeah, so how long do you have to take the test to qualify for the money back guarantee? So you have 90 days from today, from the end of the last day of class, which is today, to sit for the exam. So HR.com, yeah, thank you. Someone put the date out there. Perfect. So you do need to complete all of the practice exams and have 80%. Now, the other part of it is the attendance in the live classes too. So 80% attendance in the live sessions, as well as 80% on at least one attempt of the practice exam, so that you can qualify. And that has to be done before you sit for the exam. The exam has to be taken within 90 days of the last day of class. Yeah.
I thought there was a reading too, like a getting started that you had to
it
complete
is.
also.
Yes, you're right. Yep. The one, it's the, I think it's in the Hive. It is like, what is it? It's like preparing, like not best practices, but it's the guide to successful guide for, I think, the exam preparation. Yes, you're right. Yep. And it's like at the top of the exam. Yeah. So you read it. Yep. And you check off the section. Yeah. It's really easy. That's all you have to do. Yep. Guide for successful exam preparation. Thank you. Yep. Let's see. When did the unit test need to be finished by? I think I answered that. So yeah. So if someone's saying that they were a few minutes late, don't worry about it. If you are kind of like, the rule of thumb is if you are, I give a grace period of like 15 minutes or so. So don't be concerned about that. You will get credit for attendance for the class. So yeah. Yeah, someone's asking a confirmation. So unit testing and exam needs to be completed by the 90-day deadline. Yes, yes, exactly. So it needs to be, so the deadline is 90 days from today's date to take the exam. But before you sit for the exam, you need to make sure that you have all those components completed, like the guide to the successful exam preparation, the attendance in the class, and then the 80% on the exams. Yeah, if you did take, unless there was someone's asking, they were out. So if you missed a class, if you didn't attend the live session, then you didn't get credit for the attendance. If there was some type of circumstance that you worked out with HR.com, yeah, then let me know. And we can, or reach out to HR.com if there was some type of exception there.
Just for clarification, let's say you take the test December 20th. So you're saying in order for the money back guarantee to be applied, we have to complete everything before we sit and take the test on the 20th.
Exactly. Yes. Correct.
Okay.
Yeah. Yep. Yeah. Great question. Yeah. I mean, you have 90 days, but if you take the exam before that night, before the 90-day period, whenever you sit for the exam, like let's say that you sit for the exam next week, right? Then, yeah, I guess the 20th isn't the next week. Is next week, right? Yeah. Sorry,
Yes.
this month is getting away on me already. But yeah, that is correct. Yeah. Okay, and there's a question that's coming through to me. It looks like it was sent privately about the questions on the test. How many questions on the test and how long is the sitting? So there's a couple of different exams that this class is geared toward. So we cover kind of the hybrid. And so there should be a guide in the Hive that covers, and there was a tutorial that covered that too, that talks about the questions and how long, because we focus on, we've got, there are people that are sitting for the SCP or the CP, or it could be the PHR or the SPHR. Yeah, the Hive has the SHRM questions in the HRCP. Yeah. Yep. Yeah, that's a great question. Someone's asking about sample questions more helpful than reading. Are there more places to find sample questions? Other than the HRCP practice exams, unfortunately not that I'm aware of. There are some, well, I take that back, because on the Hive, there are the activities on the Hive too. So if you haven't done those, there's some questions out there on the activities. So those are available. And then, some of the, if you haven't attended the Coaches Corner, sometimes when I do a Coaches Corner, I put some questions out there. Depending on the facilitator style, we usually do try to have some kind of challenge points on the Coaches Corner. So take a look at that as well. There's some information there too.